Judgment in the appeal FHR European Ventures LLP and others against Cedar Capital Partners.
This appeal concerns the issue of whether a bribe or secret commission received by an agent is held by that agent on trust for its principal, or whether the principal merely has a claim for equitable compensation in a sum equal to the value of the bribe or commission. If the bribe or commission is held on trust, the principal has a proprietary claim to it, whereas if the principal merely has a claim for equitable compensation, the claim is not proprietary. The distinction is important for two main reasons. First, if the agent becomes insolvent, a proprietary claim would give the principal priority over the agent's secured creditors. Secondly, if the principal has a proprietary claim to a bribe or commission, he can trace or follow it in equity. In December 2004, FHR European Ventures LLP purchased the issue shared capital of a Monte Carlo hotel company from Monte Carlo Grand Hotel Limited, the seller, for €211.5 million. Cedar Capital Partners LLC provides consultancy services to the hotel industry, and it has acted as FHR's agent in negotiating the purchase. Cedar accordingly owed fiduciary duties to FHR. Cedar had also entered into an exclusive brokerage agreement with the seller, which provided for the payment to Cedar of a €10 million fee following the sale of the hotel company. The seller paid Cedar the €10 million on or about 7th January 2005, a month after the purchase was completed. FHR began proceedings for recovery of the €10 million from Cedar. The main issue at trial was whether Cedar had made proper disclosure to FHR of the exclusive brokerage agreement. Mr. Justice Simon found against Cedar on that issue. He made a declaration of liability for breach of fiduciary duty against Cedar and ordered Cedar to pay €10 million to FHR. However, he refused to grant FHR a proprietary remedy in respect of that sum. FHR successfully appealed to the Court of Appeal, who declared that Cedar had received the €10 million on constructive trust for FHR absolutely, and FHR therefore had a proprietary interest in the €10 million. Cedar now appeals to the Supreme Court on this issue. In a judgment of the court consisting of Lord Mance, Lord Clark, Lord Sumption, Lord Carnworth, Lord Toulson, Lord Hodge and myself, Cedar's appeal is dismissed. Where an agent acquires a benefit which came to his notice as a result of his fiduciary position, or which he obtained pursuant to an opportunity resulting from his fiduciary position, the general equitable rule is that he is to be treated as having acquired the benefit on behalf of his principal, so that the benefit is beneficially owned by the principal. Cedar contends that the normal rule should not apply to a bribe or secret commission paid to an agent, because it is not a benefit which can properly be said to be the property of the principal. FHR argues that the normal rule should apply to a bribe or secret commission received by an agent, because in any case where an agent receives a benefit which is or results from a breach of the fiduciary duty owed to his principal, the agent holds the benefit on trust for the principal. There are two principled arguments both ways, but FHR's case seems the stronger. FHR's formulation also has the merit of simplicity, whereas that of Cedar is more likely to result in uncertainty. Wider policy considerations also support FHR's case. Bribes and secret commissions undermine trust in the commercial world, and one would expect the law to be particularly stringent in relation to them, and certainly no less stringent than in relation to other benefits received by an agent in breach of trust. The argument that rejecting Cedar's appeal would tend to prejudice an agent's unsecured creditors has limited force in the context of a bribe or secret commission. In any event, it is just that a principal whose agent has obtained a bribe or secret commission should be able to trace the proceeds of the bribe or commission into other assets and to follow the proceeds into the hands of knowing recipients. While the position is less clear when one examines the decided cases, taken as a whole, the authorities support FHR's case. With the exception of the House of Lords decision in 1862 in Tyrrell and the Bank of London, They were constantly in favour of bribes or secret commissions paid to fiduciaries being held on trust for the principal, until the Court of Appeal decisions in Metropolitan Bank and Hiren and in Lister and Stubbs in 1880 and 1890 respectively. Although not followed by the Privy Council in 1993 in Attorney General of Hong Kong and Reed, those decisions were followed in a number of domestic cases, including most recently Sinclair and Versailles in 2012. The decision in Tyrrell should not stand in the way of the conclusion that the law took a wrong turn in Hiren and in Lister, and that those decisions, and any subsequent decisions insofar as they relied on or followed Hiren and Lister, should be treated as overruled. The court is now adjourned.